I'd like to introduce Cor Blonk. Cor is replacing Ment. Unfortunately, Ment is ill today, and we've sent our best to him. But Cor is from the Dutch Shipowners Association for Pelagic Fisheries, so thank you very much for attending. And Cor is going to read a letter from Ment.
Thank you very much. Thank you for the opportunity to be here, at least to give you a point of view from the angle of the fishing industry, the ship owners. As said, Ment's health state didn't allow him to be here, and I read a letter to you. We have no slides, so you're allowed to close your eyes and listen even more careful. Dear guests, dear participants, I do apologize for not being with you today. Each and every flag state has the responsibility, the duty to ensure safety of life and property at sea. Not only in shipping, also in fishing. That is what Article 94 of the United Nations Convention on the Law of the Sea requires, and most flag and coastal states around the world are bound by it. The human right to live the right to live is a human right. A flag state's duty does indeed concern the safety of fishers' lives. Under its internal law, the state must take legislative measures concerning the safe construction of seagoing fishing vessels and their equipment, safe manning of fishing vessels, training and certification of fishing vessel personnel, and working and living conditions on board fishing vessels. Flag states have a duty to mold such measures after international agreed standards and international customs and practices. I have used the word mold deliberately, because molded also means covered with fungi due to the expiration of the best before date in moist conditions. Where fishing is concerned, the international social standards available are indeed mold, if you compare it with their equivalents for shipping, and they are molding because they have hardly ever introduced in national legislation, leaving aside example of flag states that take their responsibility nonetheless. The International Maritime Organization, the IMO, has set standards for fishing vessels, safety, and for training, certification, and watchkeeping in fishing. However, the so-called Torremolinos Convention on Fishing Vessel Safety of 1977 is not enforced, despite the amendments that were adopted in 1993 and 2012, and despite the convention limited scope, fishing vessel of 24 meters and over. The International Convention on Standards of Training, Certification and Watchkeeping for Fishing Vessel Personnel, 1995, known as the SSTWF, came into force September 2012. 17 years after its adoption and almost 35 years after its conception, because its text is based on the 1978 International Convention on Standards of Training and Certification and Watchkeeping for Seafarers. Only 17 states have ratified the SCCWF so far. The International Labour Organization, the ILO, has set labour standards for fishing. Judging from the relatively large number of items in the media on modern slavery, child labour, human trafficking, and deplorable working and living conditions in some parts of the fishing sector, it may come as a surprise, but ILO's 1998 Declaration on Fundamental Rights and Principles at Work applies to fishers as much as it does to other workers. There's no real need for states to ratify ILO fundamental conventions. They just have to apply them to give fishers the right to organize themselves in trade unions and close collective bargaining agreements, and to protect them too against forced labor, child labor, and discrimination at work, whether these fishers work on fishing vessels flying their flag of the home country or foreign flags. But the ILO has done more for fishers. As early as 1920, the organization adopted a recommendation for working hours in fishing. In 1959, it adopted 3 conventions, those on minimum age, medical examination, and articles of agreement. In 1966, 2 more conventions were adopted, those on competency certificates and on crew accommodations. These 5 conventions never received much reward, in particular not outside Europe. Over 80% of all fishing activities take place under non-EU flags. By the end of the last century, the ILO started the process of updating and codification of these existing conventions for fishing. After 3 sittings in 2004, 2005, and 2007, this process resulted in the Work in Fishing Convention 2007, known as C-188. The convention was adopted by the tripartite 2007 International Labour Conference almost unanimously. The Work in Fishing Convention 2007 only requires 10 ratification, 8 of which by coastal states to come into force. Today, 9.5 years after its adoption, the convention is not in force. Only 8 countries have ratified it so far. Its shipping equivalent, the Maritime Labour Convention, the MLC, required 30 ratification by countries with a total share in the world's gross tonnage of ship of at least 33%. The MLC came into force on 20 August 2013. To date, the convention is blessed with 79 ratifications. When it comes to observing flag state duties, this is exemplary for the importance that is normally being given to shipping over fishing. The reason behind it I fail to understand. To place matters into perspective, there are about 1.5 million seafarers, 1.5. There's an estimate of 35 million active fishers, 35 million. It means that 1 in every 1.4043 persons, so from every 25 every 25 persons working in the maritime industry, 24 are fishers. Employed in the maritime industry is a fisher. Looking at these figures alone, is it not embarrassing to now know that seafarers who share the sea and oceans with fishers are better protected than fishers, who provide very large number of human beings with healthy, highly nutritional, natural food. But that's not the only perspective. Governmental and non-governmental organizations have rightly shown great concern over the often deplorable state of world's biological resources of the sea and the oceans. These justified concerns have resulted in one of the highest regulated sectors of economic activity. Although the Food and Agricultural Organization, the FAO, in its Code of Conduct for Responsible Fisheries, 1995, which is based on the law of the sea, advocates alignment of fisheries policy with policies on the safety of life at sea on basis of international agreed standards, in practice governments seem to have difficulty observing these principles. On paper, fish and fish stocks are often better protected than fishers. I now have to say a few things about the European Union, but I promise to avoid the B word. The European Union has a common fisheries policy, the CFP, that tells its member states and their fishers how to protect the biological resources of the sea and the oceans, and how to punish those who do not observe the policy. The policy does not tell the member states how to protect their fishers. As a matter of fact, the impact of measures under the CFP on safety at sea in fishing are hardly ever seriously assessed. For example, In renewing the Common Fisheries Policy in 2013, the Union introduced the so-called landing obligations. All fish caught must be landed whether the fish is marketable or not. Apart from all criticism that could be and has been expressed on the obligation, the social partners asked the European Commission to have the impact of the measures on the safety of fishers' lives at sea assessed. The Commission bluntly refused. Safety of life at sea in fishing is not part of the Common Fisheries Policy. Safety of life at sea in shipping is part of the Common Transport Policy. The European Union has transposed all three social pillars for safeguarding life at sea in shipping into Union legislation. The International Convention for Safety of Life at Sea, SOLAS, the International Convention of Standards of Training, Certification and Watchkeeping for Seafarers, SCCW, and the Maritime Labour Convention, the MLC. For fishing, the Union has been far less active. It has indeed implemented the Torremolinos International Convention for the Safety of Fishing Vessels, but this convention only applies to fishing vessels over 24 meters in length, while most Union fishing vessels are less than 24 meters in length. Although there has been much pressure on the Union to also implement the International Convention on Standard of Training, Certification and Watchkeeping of Fishing Vessel Personnel, the STCWF, so far she has only given her member states permission to exceed the convention, much without effect, by the way. The European Commission invited the social partners in sea fisheries to enter into a so-called social partners agreement for the purpose of having the Work in Fishing Convention implemented in Union legislation by a Council decision. The social partners in shipping had successfully made such an agreement on the Maritime Labour Convention in May 2008, and that one had been transposed in less than a year, in February 2009, by means of Council Directive 2009/13/EC. The Social Partners Agreement on the Work and Fishing Convention was signed in May 2012. It took the Commission 4 years to propose transposition of the agreement. Under the recent Dutch presidency, the Council could then not reach a decision. Word has it that Member States had different opinions about the procedure to follow for taking the decision. Should it be qualified majority or should it be a decision to be taken unanimously? The rights of a fisher against the fishing vessel owner to medical care on board and abroad, where the responsibility state security does not reach, seem to be procedural, not substantive. Stumbling blocks. Similar provisions in the agreement on the MLC apparently did not invoke a similar delay. And that is the state of play where human rights and rights at work in fishing are concerned. Most of the indispensable international standards are not in force. We still have a long way to go, but I will not give up and trust you won't either. In the meanwhile, public opinion is set to demand social labels in addition to labels of sustainable fisheries. Where governments fail to implement the international agreed social standard, the sector itself has to implement them. The biggest questions are, however, what can reasonably be asked from the sector without supporting an enforced legislation? Which framework to use? How to ensure a level playing field? How to ensure that social labels will not slide down into window dressing? I wish you a successful conference and I do hope that you later today, when you walk away from this place, you will be determined to use your influence to ensure that at least your administration and government will make haste. Fishers deserve it. Was signed, Mint van der Zan. Thank you.